What would I be thinking if I was on the Karen Reed jury? That's the question for today, and in just a moment, I'll let you know. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Well, this is an interesting intellectual exercise, a thought experiment, if you will, because I know things as this channel's operator that the jury doesn't know. I've had access to a wide body of information from all my subscribers, and many people have had some really excellent things to say to me and some comments on the evidence that I have sort of internalized. So I have to separate that information from the information that's been presented in court through the witnesses. That's going to be hard to do, but I'm going to try to do it anyway. I'm going to try and explain where I would be if I was sitting in judgment on this case. Simply put, the state has screwed this case up beyond belief. If I were sitting there, I would be really annoyed. The jurors, I would think, would have a great deal of trouble with, particularly people like Buchanan and Gallagher and some of these other folks who've testified and can't answer a question. And then you watch the other people who are scientists who are asked questions and they answer right away without any attempt to evade the questions. So again, I think the state or the Commonwealth, however you want to put it, I think the Commonwealth has done a bad job with this and they've made huge failures of proof, and that's why it's easy. Again, I would think that there would have been a much more robust investigation than there was. And the investigation that they have put on at trial, frankly, is embarrassing. I really think to understand where a jury has to be in this case right now, the first thing we have to understand is what the state needs to prove in order to get a conviction. There are three charges involved in this case, and the first, most serious charge is second-degree murder. The elements of second-degree murder are: 1. The defendant caused the death of John O'Keefe. 2. The defendant intended to kill John O'Keefe, or he intended to cause grievous bodily harm to John O'Keefe, or 3. See that he intended to do an act in which the circumstances known to the defendant, a reasonable person would have known, created a plain and strong likelihood that death would result. The other two charges are DUI manslaughter and leaving the scene of a death injury accident. And I won't get to those because I think we are covered with my analysis on the first cause of action, which is second degree murder. That's what's necessary for a second degree murder conviction. Those are the elements. That tells you what has to be proved, but it doesn't tell you how the state intended to prove any of that. How they intend to prove it is through their theory of the case. While she was driving in reverse, she intentionally hit John O'Keefe, knocking him into the snow, tearing up her taillight, driving away, and leaving him to die out there. In looking at this logically, based on the opening statements of both parties and the evidence so far, I have seen no evidence that she intended to kill John O'Keefe on the night of January 28th or 29th in the morning, whenever it was that she supposedly ran him over. Did they have words? Yeah, but all couples have words. Did she threaten him? No. If she had formed the intent to kill John O'Keefe prior to January 29th, it's doubtful that she would have manifested that intent by being close and intimate with him in the two bars where they were seen that night. More importantly, if she'd formed that intent and actually intended to run him over, it made no sense for her to call his cell phone and leave messages or go looking for him, because she would have known where he was. In essence, the state wants a jury to believe that she discovered her own crime that she didn't know she committed, but she did intend to commit. If that sentence makes your head spin a little bit, well, it makes mine spin a little bit too. How does someone who is leaving voicemails just a few hours earlier asking if he was cheating on her not recognize she hit him if she indeed had hit him. That's crazy. So, intent is the first really big problem that I would have as a juror. I don't think they have shown that. Now, they've added a lot of what I would call emotional evidence to try and get you up to that point where you're willing to buy into the first little slight as reason for homicide. A more judicious look at the evidence, I think, would lead away from that kind of conclusion. Now, we have to recognize that the state has the burden of proof to prove the methodology associated with his death. They have to prove that she hit him. They have to prove that that is what killed him. And they have to prove all of that beyond a reasonable doubt. Beyond a reasonable doubt means it leaves you firmly convinced with her guilt. And there is just too much pointing in the other way. Their approach appears to be that he was hit by the SUV. But one of the first witnesses in this group, or not first, I guess, one of the middle witnesses in this group was the medical examiner. And she said that his injuries were inconsistent with being hit by an SUV, and she refused to rule it a homicide. So again, that to me, right there, establishes reasonable doubt. Can any of the other state's witnesses overcome that reasonable doubt? Well, certainly the information from the car, if it is to be trusted, could establish a collision with a human body if the car had recorded such an event. That would be significant. But as the state's own expert admitted, we just don't know what happened to John O'Keefe. If we don't know what happened to John O'Keefe, what are we doing here? Are we supposed to guess as to how this happened? Are we supposed to roam freely through the evidence and pick and choose acts and non acts to determine that he was murdered? Because if we are, that's a violation of due process. So that's my lawyer hat taking over, but again, it's hard to separate some of this stuff. So the mechanics of this are very difficult for me. If he'd been hit by a car going 24 miles an hour with sufficient force to knock him into the yard over by the flagpole, based on my experience with things like deer, it seems to me that there would be a fairly large dent in the SUV, and the tail light would have been just fine. Except the tail light had already been cracked. We know that. It seems to me that if he had been hit at that speed and injured thereby, there would have been blood and tissue on the SUV, or at the very least on the taillight pieces that they claim were knocked off the vehicle, and there weren't. Countervailing all of that is the testimony of Carrie Roberts and Jennifer McCabe about her saying that she had hit him, and the paramedics saying that she had hit him. Apparently, these people all believe they heard her say, "I hit him." I believe they probably did hear her say, "I hit him," but it was as part of a question. Did I hit him? So, from a strictly logical point of view, she did say it, "I hit him," but she didn't mean it as a declaratory statement. She meant it as an interrogatory. Obviously, some proof of a collision could have been discerned from Dr. Welcher or Shannon Burgess's testimony if they had established it. But it was Dr. Welcher who told us we just don't know what happened to John O'Keefe. He went through a demonstration where he aimed his arm at the tail light, but that to me did not prove that the injuries to his arm came from that. And perhaps more importantly, it didn't prove that she hit him. Because if he had seen the car coming, he would have gotten out of the way. He wouldn't have tried to stop it with his forearm. I find it difficult to believe that the state hired Shannon Burgess. Shannon Burgess was a lot more humble than Welcher, who I found to be sanctimonious and arrogant. But Burgess was clearly unqualified. I find it difficult to believe that the state would hire somebody who didn't have a terminal degree in criminal justice to pick through the infotainment system in the car. Hiring a guy who can't put it back the way it was when he got it is another indication of ineptitude and possible negligence. It is hard to credit the testimony of Mr. Burgess simply on the basis that he lied repeatedly on his CV and LinkedIn resumes. He wanted to get hired. He didn't care if he had to lie to do it. And as the phrase goes, falsus in uno, falsus in omnibus. If you lie about one thing, you will certainly lie about something else. Now, according to the jury instructions that the jury will be given, second-degree murder is murder without premeditation. Essentially, a sudden, overwhelming compulsion to kill someone, sort of like you have after listening to Hank Brennan. So it's basically height of passion murder. You get really angry and strike out, right? So if that's the case and there's not premeditation, then we have to find that there is some exciting event that caused her to snap and do this. But they were just in the car. If she was that angry, he would have run away, not walked away from the car. And none of the state's witnesses in any way testified to any antagonism or unhappiness between O'Keefe and Reed on the night in question. The video didn't show any of that from the bars. That information is simply lacking. There is nothing adduced into evidence from which a reasonable juror could make a finding that there was an intent to do bodily harm or to kill John O'Keefe on the 28th or 29th. So at the very outset, we have a total failure of proof, in my mind, on the issue of intent. That doesn't mean we don't have some evidence here that there was a great loss. O'Keefe's mom sobbed on the stand, recalling loss of her son, and Brennan played frequent clips taken completely out of context that essentially created some suggestion or admission that Karen had intended to hurt him. But again, they don't really say that. That's just the emotional response that he wants from me, the juror. I don't think I'm ready to give that to him. Interestingly enough, those interview tapes can't be cross-examined. And we don't know what happened before that clip or after that clip, whatever that clip was. We don't have context for the individual clips. And devoid of context, you can't have any real understanding of the meaning of those clips. And I would also point out, sort of putting on my lawyer hat here, the rule of completeness should have allowed for there to be a whole airing of the entire interview, not simply selected portions. So stepping out of my juror mode into my lawyer mode, I find that to be very disconcerting. And now I'll take that hat off, put my juror hat back on. While the text messages that they exchanged on the 28th do indicate some discord, the person who seems to be not interested in being lovey-dovey was John O'Keefe, not Karen Reed. Yet in spite of this, they were seen at the bar on the night of the 28th and the morning of the 29th in good spirits, holding on to one another like they cared about one another. And I think that's pretty hard to fake. The sad fact is that Brennan has done a good job of painting Karen Reed as a bad person. She mocked the mother of the decedent. You'll pardon the pun, but she's been a bit of a Karen at times in this case. But again, in spite of that, Michael Camerino, a friend of John O'Keefe, testified in the state's case that he did not observe any strife in the relationship when he was around the two of them, based on what he knew they were a normal, affectionate couple. But he noted that Reed did not want other women around O'Keefe. So that proves that Karen Reed is essentially just like every other woman I've ever known. They don't want other women messing with their men. They really don't want other men hitting on their men either, I can tell you. But the bottom line is, she's just acting like a normal woman would act if she thought somebody was trying to horn in and steal her man. Color me not curious about that. The Commonwealth also tried to prove inebriation through the admission of laboratory testing done hours after the time when any collision could have occurred. Since Karen Reed is not going to be capable of testifying in the state's case, they can't call her. They can't establish whether she had anything to drink after she got home, something that would have raised her blood alcohol level. But even that, even at the time that she has tested in a manner that is different from the way they establish DUI convictions. And the pathologist did not figure in her multiple sclerosis and other health issues. So we don't know whether it's even close to being a situation where she's actually legally drunk at the time that any of this occurred. Now, she did say earlier that she thought she might have been drunk. But again, they don't prove that by what you say in court. They prove it with a lab test that shows either that you blew a certain level on the breathalyzer or that they drew blood and they got a blood alcohol content level, and that's what, causes the problem. They didn't get any of that. And that also is a big problem, I think. So whether she was in fact drunk at the time isn't known because they didn't test her at the time and that any supposed collision occurred. And if they had, they might have ruled out the fact that she had something else to drink after she got home. After all, she was somewhat upset that John went to that after party. As a juror, I would also be very interested in why it is that whenever evidence favors the state, we have to accept that their expert is right about the timestamps on the query about how long to die in cold. That it wasn't actually at 2:27, but at some later time, a time that's much more convenient for the state. But somehow the phone must have put the wrong time on there at 2:27, which means that if it was actually done at 6 o'clock, then the phone traveled through time in order to put that on at 2:27. That just does not make sense. Nor does it make any sense for Karen to have asked Jennifer McCaig to Google how long to die in the snow. She found John in the snow. She didn't need to Google that information because she could see that he was cold and blue, and of course, at that point, he was probably already dead. She had no reason to check. In terms of witnesses, Jennifer McCabe had a good direct examination, but was completely destroyed on cross examination over the course of several days. By the end of her cross examination, I wasn't even sure I could believe that her name was actually Jennifer McCabe. If I'd been sitting on that jury, I would have written off everything she said. Then there's the issue of Ryan Nagel's testimony, saying that he never saw John O'Keefe outside of Karen Reed's car. If he was going to get hit by the car, he would have needed to be in it because she pulled up directly and he pulled in behind her. He got interested in things, Nagel did, and he didn't see John go into the house, but as he drove by, he didn't see John in the car either, which tells me that he had gone into the house. So since the theory was that she did that on her way out, that she backed over him, that just doesn't make any sense to me. And it also doesn't make sense that John would have just stood there and allowed himself to be run over. He would have seen the car coming and he would have gotten out of the way. He was a police officer, for heaven's sakes. People try to run cops over all the time. He's going to be aware of that kind of thing. Wearing my juror hat, it would appear to me that every time the state puts points on the board, the defense comes and takes them off. Usually they did that in pretty grand fashion, too. The cross examinations were always lit and always better than the direct examinations during the state's case in chief. Then, of course, I would have had to have gotten used to Brennan's voice, which I've described as like a rusty nail going through your eardrum. I don't know what I could have set for the whole period of time that these jurors have done. The jury has done a remarkable job. I could not have done that and retained my sanity. There are some people who think that maybe I didn't retain my sanity, but that's an entirely different question. The medical examiner again pretty much sealed the deal on the collision, saying there's no collision, and I'd be sitting there wondering, after hearing her testify, what in the world are we doing here? And it never got any better during the rest of the state's case. Gallagher, terrible witness. Buchanan, he couldn't answer a question to save his soul. And he pretended not to understand English when it benefited him. That's just not the way a good police officer answers questions during a trial. At the end of the state's case, I could not see that they had proved that she had hit him with the car. And if they can't prove that she hit him with the car, then count 2 and count 3 go away because they both involve being hit by the car. So the only thing they're left with is murder 2. And again, they have to prove intent on murder 2, and they have to prove a collision because that's their theory. Now, that doesn't even factor in all of the problems with the chain of custody, no securing of the crime scene, especially the house, no talking to the witnesses. That's those are the kind of things that create lots of reasonable doubt. If a juror wanted to be pig-headed, and they certainly could be, they could go solely on the basis of Karen Reed's statements in those isolated clips. They could go solely on the basis of what the prosecution alleged in their opening statement, even though they're not supposed to, and simply disregard the requirement for proof, which seems to be what a lot of the trolls who are convinced that Karen Reed is guilty are doing. The bottom line is that if I'm on the jury at the close of the state's case, I'm not voting guilty. I'm voting not guilty. And now, several days into the defense case, I'm not only voting not guilty, I'm saying it's time for pitchforks and torches. Let's go charge the courthouse. They should find this gal affirmatively innocent. And I would be terribly upset with Hank Brennan for the way he had been treating those witnesses in the defense case, especially Dr. Russell and Lucky. Those were unforgettable breaches of etiquette and just incomprehensible to me. Lawyers are always taught to be nice to witnesses. Ask hard questions, but don't be personally offensive. Apparently, Mr. Brennan was absent that day in law school. I do believe that Karen Reed is not guilty, and I believe that the evidence has shown that, and not shown anything else. People often say things that are stupid. They often have arguments. They often make up after those arguments. The most probative information about the status of the relationship is the way they were acting together on the night of the 28th. And yes, while she was very upset later that he was staying at the after party, she wasn't homicidal. I would say not guilty on all counts. Now, why do I say not guilty on all counts? Because in order to get to negligent homicide, you have to have a collision, and they didn't prove a collision. And in order to prove DUI manslaughter, they have to prove a collision, and there was no collision. And she wasn't charged with simple DUI. I can't wait for the defense to rest so this can go to the jury. I think the only reasonable verdict at this point is not guilty. That's where I'd be if I was a juror. Tell me how you'd be if you were a juror. Drop some comments and let us know.
That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.